Hello students, welcome to Eduauraa. My name is Dinesh Ahirrao, your teacher for Indian Polity session. What is the law of the land? Now, laws basically are those laws which are used in the administration of the country and are legally enforceable in the country. Right? So, law of the land means all laws which are used in the administration of the country and which are legally enforceable in the country. All of us are expected to obey those rules and laws. Now, law of the land includes following 7 things. Let us discuss these 7 things one by one. So, first is the Constitution. So basically, we are discussing what is law of the land means or what is law of the land includes. So first is Constitution. Now, Constitution, it is also a legal document. Like law, it is also a legal document. But Constitution, it is a supreme law of the land. Constitution is a supreme law. So this is one kind of law. Next important type of law is statutory law. Statutory law. Statute means law. Now, statutory law are made by the legislature. For example, in India, laws made by the parliament as well as state legislative assemblies, they are called as statutory laws. For example, Right to Information Act. Right to Information Act 2005. This act was enacted by the Parliament of India. That is why it is called as statutory law. Another example of statutory law is Right to Education Act 2009. This is also an example of statutory laws. Now, next law of the land is ordinances. Now, what is ordinance? Basically, Constitution of India under Article 123 empowers President of India to promulgate an ordinance when the Parliament is not in session. Similarly, Article 213 of the Constitution empowers governors of the respective states to promulgate ordinance when the state legislative assembly they are not in session. So remember these two articles, Article 123 and Article 213. Article 123 empowers President of India to promulgate ordinance when the Parliament of India is not in session. Whereas Article 213 empowers the governors of the state to promulgate ordinance when the state legislative assemblies they are not in session. Remember, President as well as governors, they cannot promulgate the ordinance when the Parliament or the state legislative assemblies they are in session. It is only when Parliament is not in session, President of India can promulgate the ordinance. Now, what is the difference between the statutory laws and ordinances? Now, this is very, very important. I have already told you that statutory laws are those laws which are passed by the legislature, be it Parliament or state legislative assemblies. Now, we have just discussed the ordinances. Now, the difference between the statutory laws and ordinance is that statutory laws are permanent. They are permanent in nature. Whereas ordinances are temporary. Why ordinances are temporary? Because ordinances has to be placed before the Parliament as well as the state legislative assembly, as the case may be. And it is only when Parliament approves the ordinance becomes the statutory law. According to the Constitution of India, the maximum duration within which the ordinance remains valid is 6 months and 6 weeks. Right? So that is the duration of the ordinance, maximum duration of ordinance. So statutory laws are permanent in nature, whereas ordinances, they are temporary. An ordinance has to put in front of the floor of the Parliament, and ordinance becomes laws only when the Parliament approves that ordinance. Now this is the difference between statutory laws and ordinance.